Good afternoon, my lord. My name is McGivney, and I appear on behalf of the pursuer. The case today is calling as a debate to deal with issues relating to liquid and illiquid debts and the right of retention, supported by the Rule 22 note lodged with the court. My lord will have to have before him the close record, number 8 of process, the Rule 22 note, number 9 of process, the pursuer's productions, number 5.1 of process, and the list of authorities, number 12 of process. Does your lordship have those before him? Thank you, my lord. Has your lordship also had a chance to read the record and the list of authorities which will be relied upon today by the pursuer? Thank you, my lord. My lord, at the end of my submission, I will invite you to sustain the pursuer's first plea in law and grant a decree in the amount of £39,600. This is the whole sum which the defenders have admitted they owe the pursuers. It is also the sum asked for in decree in the initial writ, less £3,600, which is the amount arising in a disputed contract in this case. The defenders' pleas in law and the principal action should also be repelled, and my lord, if successful, then the pursuer submits that the counterclaim in this case is to be determined separately, and a proof before answer should be fixed to deal with it, while at the same time dealing with the disputed contract in this case, number 5.1.11 of process. My lord, the pursuers in this case are claiming that the defenders owe them £43,200 for asphaltic road surfacing materials supplied to various sites over 13 contracts between June and November in 2020. The pursuers are arguing that the defenders have refused to pay invoices despite delivery and acceptance of the goods. The defenders have attempted to use the defence of retention of the sum owed to the pursuers on the basis that the asphaltic road surfacing material from the disputed contract on one occasion allegedly caused damage, resulting in remedial work needing done, and the defence have counterclaimed on this. My lord, the defenders have admitted the terms of the contracts which the pursuers are relying on, and their only defence, as outlined above, is retention, which is only relevant in relation to the one disputed contract. That is the invoice which is dated the 26th of November 2020 for the amount of £3,600. Your lordship, to aid you in understanding the pursuer's arguments, may I direct you to condescendence 2 and answer 2 of the close record, where your lordship will see here that in answer 2, the defender admits all of the pursuer's averments, where they state, admitted under the explanation which follows. In the remainder of the answer, we see the defender admit to the supply of the goods under the contract in every case, apart from the disputed one. My lord, if I could now direct you to the second section in the statement of facts and answers in the counterclaim. Here your lordship can see the defender admit they are only claiming one of the lots of asphaltic road material was faulty, where they say the asphaltic road material they supplied to the site in Kirkcaldy on the 25th of November 2020 was too cold. My lord, the defenders have admitted that they owe the pursuer liquid sums due on contracts where they have not claimed the pursuer's product was defective, whereas what the defenders are stating they are owed in the counterclaim is an illiquid sum. The law sets out that liquid sums, such as those owed to the pursuer in this admitted liability claim for a fixed sum of money, cannot be set off against an illiquid sum, such as the defender's nebulous damages claim, which is denied and may or may not be due. In McBride's The Law of Contract in Scotland, Chapter 14, Paragraph 63 sets out that because damages are illiquid, there are difficulties in claiming that the amount of damages should be set off against a contractual claim, such as that for a price, as is the case here. Chapter 20, paragraph 62 goes on to state that the Compensation Act of 1592 allows liquid debts to be set off against each other, but does not apply to illiquid debts, and that in mutual contracts, parties may withhold performance when they have illiquid claims, but not because of the Compensation Act, but because of the mutuality principle. The present case is not resolved by either of these remedies, as we have a liquid debt and an illiquid debt where the principle of mutuality does not apply. I will expand on how later, Your Lordship. Paragraph 64 of the same chapter goes on to say, most important of all, retention does not operate to extinguish claims, which is exactly what is attempted here. McBride then competently summarises the court's position in this type of situation in paragraph 65 of chapter 20 by calling this type of situation an incompetent set-off. If I could now direct Your Lordship to the case of Purac Limited against Bizac Limited, held in 2005, reported in Scots Law Times, starting at page 37. This is the first case in my list of authorities, which is number 12.1 of process. In this case, my lord, two companies, Purac and Bizac, entered into a construction consortium agreement for the construction under a separate contract of a wastewater treatment centre for a third company, West of Scotland Water. The agreement set out that Bizac, as lead contractor, would pay any money which was due to Purac within 5 days of receiving it from West of Scotland Water. Purac sought an order ordaining Bizac to make payment of £385,594.01, which had been withheld. They also sought a declarator stating that Bizac was not entitled to withhold the payment. Now, Bizac had accepted that the sum had been certified as due under the contract and that they had withheld it, but they stated that no sum was due because the construction consortium agreement had set out that only the net balance would be due to Purac after offsetting any sum due to Bizac for Purac's defective performance. And secondly, that the common law right of retention applied to the contract, meaning Bizac were entitled to withhold the sum of money until it could be set off against any compensation payment. Now, the court held that A, the consortium agreement by itself was not enough to achieve the result, that only the net balance was due, and B, that the defenders had pled the relevant defence of retention, and that breaches of contract which were averred were substantial, if made out, and the inability of Bizac to retain the sum, which was about 28% of the contract with West of Scotland Water, would have clearly threatened their benefit that the defenders might have reasonably expected from obtaining the contract. And thirdly, that the decisive consideration was honouring the integrity of the contract which the parties had entered into, which outlined that the right of retention should prevail over any obligation to pay. Therefore, the pursuer's motion was refused. Now, my lord, the pursuer here will now attempt to distinguish this case from the case at hand. So if I could ask your lordship to turn to paragraph 10 of the judgment, where Lord Drummond-Young sets out the 4 features of the right of retention, which he deemed called for his comment. Does your lordship have sight? Thank you, my lord. My lord, Lord Drummond-Young states, first, the right only arises if the two obligations are themselves interdependent, or, as is sometimes said, are counterparts of each other. My lord, in the case at hand, clearly the only interdependent obligations are to do with the contract which is in dispute. For the other 12 contracts, the obligations are entirely not interdependent, and therefore it cannot be said that the right of retention arises. Lord Drummond-Young then sets out that secondly, the right only arises where one party is in material breach. Now, my lord, only the contract which the pursuers have allegedly breached could be a material breach, the disputed one, and there is no alleged breach for the other 12 contracts. Lord Drummond-Young's third point goes into detail about what a material breach is, but as just established, there is no alleged breach in the other 12 contracts, and therefore it is irrelevant in relation to those. Lord Drummond-Young's fourth point just discusses that the right of retention applies to building contracts the same way it would any other case. My lord, another distinguishing feature in this case to the case at hand is that there is no such stipulation in the contract in our case, which sets out the right of retention should take precedence over any right to pay. If I could now direct your lordship to the case of Barton Distilling Scotland Limited against Barton Brands Limited. This was held in 1993, also reported in Scots Law Times, starting at page 1261. This is the second case on my list of authorities, and it is number 12.2 of process. My lord, in this case, whisky suppliers Barton Distilling sued for payment for a quantity of whisky which was supplied between June and July 1990. Now, the purchasers Barton Brands admitted to the supply, but counterclaimed for a sum in excess of the value of the whisky. The basis for this was that the companies had engaged in a course of dealing, and at one point in this course of dealing, the suppliers had agreed to supply the defenders with a large quantity of whisky with the intention of them selling it on, and they'd failed to supply them with this quantity, which resulted in them breaching the contract, causing the defender to suffer a loss of profit for which they are now counterclaiming. Now, the parties were agreed that the principal action was for a liquid sum and the counterclaim an illiquid one requiring proof. The pursuer contended that the defenders were not entitled to retain the sum sued for merely by showing the various transactions formed part of a course of dealing, arguing that unless a single contract existed, or a series of contracts which could be viewed as a single contract to the extent that there was true mutuality between the parties in respect of all matters arising in the series of transactions, then the plea of retention could not set off an illiquid sum against a liquid one. The defenders argued 4 exceptions to the general rule against a plea of retention and claimed that they could rely on the first, second and fourth exception. The court held in relation to these exceptions that firstly, the instant verification exception could not be invoked as there was no proof of the failure to supply the whisky, nor was there proof of the market value of the whisky to determine the counterclaim. In relation to the fourth exception, the court held that the present case involved 2 commercial entities and there was nothing to justify the court exercising its equitable discretion to allow the right of retention to be pled on a case-by-case basis, as is the case here in the case at hand. Now, for the more pertinent point to the case at hand, in relation to the principle of mutuality, the court held that although the principle could be extended to apply to 2 or more separate contracts where the parties had so agreed, there were insufficient averments on record to establish that the supplies on the different occasions had any agreed quality of mutuality. The court then granted decree in the principal action and fixed a proof before answer for the counterclaim. The case at hand is the same as that in Barton in relation to the contentious matter of the principle of mutuality, my lord. The principle does not apply to all 13 contracts as the parties did not agree to this, and there are insufficient averments on record to establish that the supplies on the different occasions had any agreed quality of mutuality. If I could now direct your lordship to the case of Inveresk Public Limited Company against Tullis Russell Papermakers Limited. This was held in 2010 in the UK Supreme Court and was the 19th case that year. This is the 3rd case on my list of authorities, number 12.3 of process. My lord, in this case, the appellant Tullis Russell appealed against a ruling that it was required to pay the respondent Inveresk the sum of £909,395, and the ruling that the plea of retention was irrelevant. This sum is in relation to a sale by Inveresk to Tullis Russell of property rights in a brand of paper, customer information and related assets. The transaction had been recorded in 2 documents: an agreement for the acquisition by Tullis Russell of the brand, customer information and related assets, known as the Asset Purchase Agreement, and an agreement by which Inveresk undertook to continue to manufacture, sell and distribute specified products for a 5-month period or until the agreement was terminated, the Services Agreement. Now, in a recital to the Services Agreement, it was stated that Tullis Russell had requested that Inveresk enter into that agreement to ensure continuity in the manufacture and distribution of products and facilitate this integration into Tullis Russell's operations and enable it to obtain the full benefit and value of the assets being acquired under the purchase agreement. The consideration for the assets that Tullis Russell was to acquire under the asset purchase agreement consisted of an initial sum of $5 million and a further sum as additional consideration. In the action, Inveresk had sought payment for the £909,395 as additional consideration. There was also a second action in this case where Tullis Russell had sought damages of over $5 million on the basis that Inveresk had failed to manufacture paper products during the currency of this services agreement that complied with the relevant quality standards and that it had dealt with customers in a way which diminished the value of the assets. So the issues in this case were twofold: whether the date for the payment of the sum claimed by Inveresk as additional consideration had fallen due, and whether Tullis Russell was entitled to withhold payment of the sum due, pending the outcome of the damages claim. Now, the court allowed the appeal, holding that firstly, the date for the payment of the sum had not fallen due, but more importantly to the case at hand, the court held that Tullis Russell was entitled to withhold the payment of any sum which was due to Inveresk while awaiting the outcome of the damages claim. The remedy of retention here rested on the mutuality of contractual obligations, and retention could be relied on where the respective obligations arose under different contracts. Further, that the asset purchase agreement and the services agreement were clearly part of the same transaction. Tullis Russell's obligation to pay the additional consideration to Inveresk was a counterpart of the performance by Inveresk of its obligations under both agreements. Behind those arrangements was Tullis Russell's concern that the value of its investment could be affected by Inveresk's conduct during and following the expiry of the services agreement. The basis for the damages claim was that the value of its investment in the asset purchased under this asset purchase agreement had been diminished by Inveresk's actions, and also through the way they dealt with customers. And at paragraph 110, the court held that they are unquestionably closely interlinked, the two agreements, that is, my lord, and form part of the same overall transaction. In our present case, not only are the contracts not interlinked in the same way as the agreements here, but they also do not form part of the same transaction. My lord, the case at hand has 13 contracts, which are not linked in the same way as the two agreements in this case, just previously outlined, which were clearly linked with mutual obligations and formed part of one contract, and for those reasons the principle of mutuality does not apply in the same way. The pursuer therefore asks your lordship to sustain the pursuer's first plea in law in the principal action, hold the defence of retention as irrelevant, and sustain the pursuer's second plea in law to the extent of £39,600 with interest. And the pursuer asks the court to repel the defender's pleas in law in the principal action. In the event that your lordship is with me, I am seeking expenses in relation to the preparation for and the conducting of the debate. And finally, as far as the remainder of the action is concerned, the pursuer asks the court to fix a proof before answer. If I can be of no further assistance to your lordship, that concludes the pursuer's submission.